Hello everyone. How are you all? My name is Kumari Pooja and I hope all of you are doing well. I hope all your josh is high and I also hope कि तैयारी बिल्कुल जोरों शोरों से चल रही है because exams are just right here कुछ ही दिनों में. Uh, Okay, so we are here to discuss about the legal updates yet again. If you have not gone through my previous legal updates, please go through that too, so that you get the wholesome idea about all the important legal updates for your upcoming examination and you are not held by any surprise in the exam. ऐसा ना हो कि कुछ unfamiliar सा लग रहा है and I'm not able to comprehend it. So always be ready beforehand for the unfamiliar passages as well. All right. So let's start with today's set of legal updates. The very first one being very interesting one that says no foreigner has the right to obtain Indian visa. This has been ruled by our dear Supreme Court. Now, what is the background story of this? So there was a vlogger from New Zealand. His name was Carl Rock. So he was recently blacklisted by the center, okay, on ground of certain violation of the conditions that are mentioned in the visa. Okay, so that was the background on, and in the extension of that, the Supreme Court recently held that if there is a person who is a foreign national, he or she would not have the right to get an Indian visa. वो उनका right नहीं है. Okay, it if there's a person who is blacklisted, in such case it is the authorities who will be decided whether to give it or not. Okay, so it is on the wishes of the authority कि उनको देना है या नहीं, but no person, no foreign national can come and say that this is my right. Now if we are talking about the right per se of foreign national कि कहाँ पे foreign national can interfere. So there is this very important aspect that you all must be aware of, especially with respect to law entrance examinations. Okay, so there are certain set of fundamental rights, okay, that are only limited to citizens, and there are certain set of fundamental rights that are actually that can actually be availed by both citizens as well as foreign national, that are foreigners. Okay, but except for enemy aliens. ओके तो अगर हमारा सपोज वॉर चल रहा है चाइना के साथ तो ऑफ कोर्स वी आर गोइंग टू गिव देम समथिंग एल्स बट नॉट आवर राइट्स राइट सो that's what you must be aware of. Now, which all are the rights, fundamental rights that are available for only and only, specifically only and only for citizens and not for foreign nationals? First one is protection against discrimination. Other one is about the opportunities in public employment. Then there is a set of freedoms, right? Six set of right to freedom that we have under Article 19. So all of those also are only available for citizens of India. Apart from that, for the protection of language and script and culture in our country, for that fundamental right also, it is only available for the citizen of country, and also to establish educational institutions for minorities. Okay, that is also available only for citizens. Now, take your time, hold it for a second. Okay, if you want to pause, you please pause it and think about it, that all these five rights, what would happen if we provide any of these rights to the foreign national also, and particularly think of any Pakistan national. Okay, what if we tell Pakistani national that we are not going to discriminate you on the basis of this or anything on the birth of place? We are going to give you all the rights in our public employment also, means we are going to, maybe we'll give you reservation also. What if we tell them that you have all the right to freedom? If you want to move from Chennai to Kashmir, simply go to Kashmir aram se. If you want to reside in Kashmir, go reside in Kashmir aram se. Can we do that? Can we tell them that we are here to protect your language, we are here to protect your culture? Can we say them, can we actually give them a liberty to to have any, to administer any educational institute in our country as a part of right, as a matter of right? Can we do that? Just think about it. What will happen if any of these rights are given to any foreign national? Then you would understand why are we not giving these rights to them. Okay, now there is another set of fundamental rights that are given to uh, all the citizens and foreign nationals also, like equality before law, equal protection before law. That is Article 14. We are giving them protection against the conviction for offences. Yes, we are giving them right to life. We are giving them right to personal liberty, the elementary education, against prohibition, protection against the trafficking of human being. Yes, protection against the arrest and detention in certain sectors. In We are giving them protection against the employment of children. या ऐसा नहीं हो सकता कि कोई फॉरेन चिल्ड्रन आए हैं और हम उनको हैजार्डस इंडस्ट्रीज या फैक्ट्रीज में लगा दें. Yes, we cannot do that. So we have given them also rights. We have given them rights to come, profess, practice, propagate their religion if they want to. Yes, if you want to profess your religion, you are free to go. But if you start administering educational institutes on the basis of the minority that you hold in our country, फिर तो ऐसे पूरे दुनिया के लोग हमारे यहाँ के educational institutes बनाने लग जाएंगे. Yes, but we do not stop them from professing, from practicing any particular religion. Why? Because we are a secular state. Yes, that is what our preamble says. We follow secularism. Okay. Apart from that, they are free to manage their religious affairs. हो सकता है कोई बहुत ही अलग religion का हो, इंडिया में आके अपने घर में if they want to worship their भगवान on their own way, they are free to do that. We follow secularism. Yes, they are free from paying any taxes for the promotion of religion. Again, yeah, secularism. हम घुसते नहीं है. Yes, that's what secularism means. Either we do not get into any religion or we treat all the religions equally. Okay, that is what. These are all the laws, fundamental rights that are available to both citizen of India as well as foreign nationals. Okay, important one. Apart from that, there is another legal update with regard to Waqf Act. So there is a PIL that has been filed in Delhi High Court for the constitutional validity, for challenging the constitutional validity of Waqf Board. So what is important here? Important here is the ground on which the it has been challenged. Okay, so it basically says that there's a lot of rights, there are a lot of powers that we are giving to a particular Waqf board. Okay, सिर्फ एक बोर्ड को अगर हम बहुत सारा पावर्स दे दें, अनकंट्रोल्ड पावर्स दे दें, we are giving them uncontrolled powers, and that is why it becomes a threat to us. Okay, so what are the and that would be against the Article 14 and 15 also. Why? Because you are discriminating. If you are giving all the powers to them, you are discriminating against us also. You are giving uncontrolled power to them, and you have no safeguard for saving. You have no provision. You have no system for saving the interest of other communities also. Yes, so since you are not doing that, and that is why it has to be held unconstitutional. Now, there is another legal update. There's a lot of debate that is going on with regard to the official language in the court. That has what official language has to be followed in the court. Yes, you must have heard about the debates that are going around us, and it's been quite a long time since this debate has been up. So डिबेट में क्या चल रहा है वो हमारे लिए इंपॉर्टेंट नहीं है. दोनों पार्टीज बहस कर रही है, बहस करते वक्त क्या बोल रही है, दैट इज नॉट इम्पॉर्टेंट फॉर अस. व्हाट पॉलिटिक्स इज गोइंग ऑन, पॉलिटिक्स इज ऑल्सो नॉट इम्पॉर्टेंट फॉर अस इन क्लैट. what is important is the legal dimension of this debate. Okay, so basically, if you get into the constitution, Article 348 very clearly says that in High Court and in Supreme Court, English language has to be followed for all the procedures, for all the proceedings. Okay, and Article 348 also mentions that a state may authorize any other language, okay, apart from English, and they may also authorize, say, Hindi or maybe some local language. Okay, so state may authorize any such language also, but with the consent of president. Now, these are the two that we derive from the Constitution. Now, there is another statute, that is Official Language Act, wherein it mentions that a governor, after taking the permission from the from consent from the president, Okay, even a governor can authorize any language apart from English, any language, be it Hindi or any um, local language or any regional language, whatever they feel, they can also authorize any of such language for the purpose of the judgment and proceeding, and the entire system that is going on. So even a governor can authorize such language. Now these are about High Court and Supreme Court that we just studied. What about district courts? Yes, what about lower courts? So in district court, it's very simple. In CPC, it has been simply mentioned under section 137. It says that the language that has to be followed in the district court has to be same as the act. मतलब एक्ट को जिस लैंग्वेज में लिखा गया है उसी लैंग्वेज में डिस्ट्रिक्ट कोर्ट उसी लैंग्वेज को डिस्ट्रिक्ट कोर्ट में फॉलो किया जाएगा. The language that is mentioned in the act, that is being followed in the act, okay, that is what has to be followed in the district court. But also, if the state government feels that if there is any regional language, okay, if there is a state wherein there are 2 to 3 languages are being used simultaneously by a large percentage of people, okay, so in that case even state government can decide to have more alternative languages to the proceedings, okay, but the condition is they will have to take the consent from the president. Okay, so this is about the official language that has to be followed in the court. Now, the last legal update of the day is with regard to the mercy plea that is being sought by Perari Valan, that who is one of the accused, one of the convicts, actually not accused but convicts of Rajiv Gandhi assassination. Okay, so unka case कब का आया, and so far he has already served 36 years of his life term. मतलब वो 36 years तक जेल में रह चुके हैं. So now what happened? The Supreme Court decided, Supreme Court gave a judgment. It ruled that now he should be released because 36 years he served enough of sentence, so he must be released now. Okay, and there was a debate that was going on because state cabinet said that he should be released. Governor took up the matter, okay, and governor chose to ignore it. Okay, the governor of Tamil Nadu chose to ignore the advice of the state cabinet, and the matter went to Supreme Court. Supreme Court uh, said that governor should not ignore the advice of the state cabinet. And why? Because of course if governor ignores it, if it returns it, anyhow it is going to go to the president. Okay, governor को एक बार तो मानना ही पड़ेगा. So it will go to the president and the entire pardoning power, everything will go on. So basically Supreme Court stepped up here and Supreme Court said 36 years is enough, काफी है. He has served for what he did and now he should be released. हमारे लिए ये स्टोरी इंपॉर्टेंट ज़्यादा नहीं है, थोड़ी बहुत इंपॉर्टेंट है. यू मे गेट इट इन दी passage. What is important here, very important with respect to legal knowledge also, is the pardoning power. Pardoning power of the governor, pardoning power of the president. Okay. Articles 161 and Article 72 of Constitution. These two talks about pardoning power of governor and president respectively. What is pardoning power? Means suppose if there's a person who has got a punishment, okay, he's already serving a punishment, or maybe he just received certain order of punishment. Now he pleads for the mercy. वो प्रेसिडेंट को बोलता है कि मैं सुधर जाऊंगा, मैं सुधर जाऊंगी, give me, please mercy, have some mercy on me and give me some liberty. Okay, please pardon me. तो उसके लिए governor and president has got certain powers. Now, what all can they do? What all options do they have? First one is either they can pardon them entirely, means dissolving the entire conviction, entire punishment, entire sentence that has been pronounced. Okay, मतलब you are setting the person entirely free. That is pardon. Second one is reprieve. Reprieve means suppose there's a person who got, say, capital punishment, death penalty. Okay. Now, suppose his death penalty has to be executed next week, and the person pleads the president for it. So, what president can do is president can delay the execution of that punishment. Okay, suppose there is some certain procedure that is left in the court, or there is certain points that has not been highlighted in the court, there is another procedure that has to be taken by the court if the person wants. Yes, so it can be delayed by the president can allow the delay. Next one is respite. Respite means there can be certain situations, certain conditions, special conditions wherein punishment can be reduced. Suppose there's a woman who turned pregnant. Okay, suppose if she is pregnant, in that case, the quantum of or the degree of the punishment that she has got from the court, it can be reduced. Yeah, or say if there's a person जिसको बहुत ही बुरी बीमारी हो गई है कुछ, ठीक है, तो उसके लिए भी for that also punishment can be reduced. Apart from that, there is remission, means the entire punishment, the quantum of the punishment can be reduced. Matlab, it should be the same. Okay, if the court has decided that it is going to be simple imprisonment, the term of simple imprisonment is going to reduce. If the court has decided that it is going to be rigorous imprisonment for 10 years, the term of such imprisonment is going to be reduced. That's it. And the last one is about commutation, means changing the entire nature of the punishment. Suppose he was supposed to get, say, a lifetime imprisonment, but now the president can reduce it to saying कि नहीं lifetime नहीं होना चाहिए, lifetime rigorous sentence. Suppose it was that, okay, lifetime rigorous sentence, rigorous imprisonment. Now the court can say no, 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 he is turning old, we cannot give him rigorous imprisonment. So what we are going to do, we are going to change the kind of punishment he is getting. So we are going to change it from rigorous to uh, simple imprisonment. Okay, so changing the nature of the punishment is what president or governor can choose to do. Okay, so these are all very, this is very important. Okay, this again, this is one of the topics from where you can get certain question in legal knowledge also and in legal reasoning also. So please do take care of this. And yes, this was the last legal reasoning, legal update for today. And I hope this helped you. And if you have any question, if you have any doubts, please put it in the comment box. If you have any update that you want me to discuss, you can mention it in the comment box. Also, if you have any update, okay, that you want other peers to know about, you can put that also in the comment box. And please subscribe to this channel so that when I come with the next video for you all, since the exam is nearing, I'll try to come up with some very useful videos for you all. So please subscribe to this channel so that you get the notification when I come next. Yes. So thank you so much, everybody. Please take care of yourself. Keep your Josh high and all the very best for your examination.